So I am PowerPointless, and I am going to go very, very quickly so that we stay on time here. Everybody heretofore has been talking about carrots, and I'm not sure that I'm thrilled to bring you the stick, but that is nonetheless what I am bringing. I'm here to talk about class action litigation and how you can avoid being sued. And I'm not going to try to go through all of the litigation because that's not possible. What I am going to do is hit the highlights, particularly as they are relevant to your situation. First thing I want to tell you is that there are lots of ways you can get sued besides class action litigation, right? So we've had a bevy of wrongful convictions of the innocent here in Texas, and those folks can sue you and try to get money in exchange for the years of their life that were wrongly taken from them. So that's one way. Individual clients in their individual cases can also bring litigation that ultimately can result in costs to your county, if not direct judgments against your county, like in the Rothgary case, right, where that caused a groundswell change in the way we have to do business in Texas. Class action litigation, though, really began in 1985, and it has increased in scope and number of lawsuits all over the country ever since then. There's just a groundswell wave of this litigation that's going on. So in 1985, the case of what ultimately became known as Lucky versus Harris began in Georgia, and Bob Spangenberg's here and was around back then and could tell you all the details about that litigation. Lucky versus Harris was a case that the ACLU filed alleging that the state of Georgia was engaged in a statewide systemic failure to provide constitutionally adequate defense. Georgia at that time had a county-based system, but in Lucky versus Harris, they sued the state of Georgia and said, you as the state are responsible. And they asked the state to set minimum standards and to provide constitutionally adequate defense. Now, that lawsuit ultimately got dismissed and nothing happened in the state of Georgia. But it began in November of 1985, and that lawsuit went on for 7 years of litigation. So an awful lot of lawyer dollars got spent on an awful lot of litigation that bought the taxpayers of Georgia nothing. And if all that time and money had gone into improving indigent defense, they might have been somewhere. So that was the first big case that gave everybody the great idea of filing 1983 suits, right? Then in 1994, Stinson versus Fulton County was filed. In this case, they sought declaratory and injunctive relief against the county, Fulton County, against their practice, this is going to sound familiar to you, of denying counsel to indigent criminal defendants while they were in the county jail during the period between their bond hearing and when they actually got indicted and arraigned, right? It's exactly the circumstances of Rothgary. It's just in that case, they were suing for declaratory and injunctive relief. That suit got filed in 94. It took 5 years of litigation. In 1999, they finally entered into a consent order where Fulton County agreed to maintain and adequately fund a pretrial services department. So, again, 5 years worth of time and money spent on what they could have agreed to begin with that was constitutionally required. In 1996, we have Doyle versus Allegheny County Salary Board in Pennsylvania. Pennsylvania has a county-based system. And there's nothing wrong with county-based systems. It's just that when you have them, counties get sued and counties have to defend. In that suit, it was filed on behalf of all present and future indigent criminal defendants and sought to bring the Allegheny County system of indigent defense into compliance with existing statutory and constitutional obligations. Allegheny County had a public defender office model, but the suit alleged that the county had failed to abide by its duties in that it allowed the public defender system to devolve into one that had unmanageable caseloads, inadequate resources, deficient policies, and procedures. Again, 3 years of litigation, they settle, they enter into an agreed settlement, and Allegheny County was under court supervision for 7 years before they got out from under supervision. In Connecticut, which has a statewide system, we have Rivera versus Ryland. That suit was brought by the national and the state chapters of the ACLU, and it alleged that Connecticut's system was so underfunded that it systematically deprived indigent defendants of the effective assistance of counsel. Excuse me. Ultimately, the defendants implemented a series of reforms, 3 years in litigation to achieve that. In what has come to be known as the Quitman County case, but was really, 4 cases brought together in Mississippi, the twist on this one is that the county sued the state. And they were attempting to force the state of Mississippi to fund the unfunded mandate of providing public defense services. After 4 years, the circuit court finally entered judgment in favor of the state, and that judgment was eventually affirmed. So Quitman County wasn't successful from the vantage point of public defense. Counties were still stuck with the burden. The state still wasn't required to pay, but 6 years in time and money in litigation for not very much return for anyone. Montana. The White versus Martz lawsuit, again, was filed by the ACLU against the state of Montana that at that time had a county-based system, and it contended that plaintiffs were being denied the appointment of counsel altogether, in that it just wasn't occurring when they were getting counsel, that those counsel were not competent, that they were being denied the right to consult with their lawyers, and they were being denied the resources necessary to put on a defense. They got past a summary judgment in this class action litigation. They deposed over 80 witnesses. They took testimony from every public official in the state of Montana, and the Attorney General said, "Uncle, can we just suspend this lawsuit and see if we can't all come together for a little legislative fix here?" And they did. And they arrived at a statewide system of services in Montana. Now, Montana's rural, and it's big, and it's not quite as big as Texas, but it's mighty big and mighty rural. And so the system in Montana that they now have in place is not a cookie-cutter system where the services are exactly the same from place to place to place throughout Montana. But what they do have is statewide training, statewide services, statewide uniformity, statewide oversight, statewide funding. And then they tailor the delivery of services based on the particular part of the state that you're in. Montana hadn't got it perfect yet. It's not great, but they are moving forward to have the state accept its obligation. Took them 2 years in litigation before they finally reached agreement. In Massachusetts, in the LaValle case, Massachusetts has a statewide system that is almost 100% assigned counsel. So statewide funding, statewide administration, but the delivery of services, or at least adult services, throughout Massachusetts is done by individual attorneys who work in private offices and are administered much like John Dee's system that he described to you earlier today. So the lawsuit in Massachusetts was that at that time those lawyers were being paid $40 an hour. Now, any of you who've ever had a private law office will know that $40 an hour won't cover your overhead. It won't hardly cover your secretary, right? But it's not going to let you take anything home at night. And so the lawsuit said that that rate was so low that it resulted in an insufficient number of attorneys who were willing to accept assignments. The court didn't say you must raise your hourly rate. What the court said was that pretrial detainees are going to be released after 7 days if they don't have a lawyer appointed. And if 45 days pass and there's no lawyer appointed, the charges are going to be dismissed. So that got the legislature's attention. And in a matter of days of that court ruling coming down, the Massachusetts legislature passed a bill raising the assigned counsel rates. And this has resulted in an increase in the Massachusetts Committee for Public Counsel Services budget of approximately 230% over 8 years. So that's a big old chunk of change. But they had to do it. Or this was a case where the guilty were going to walk right along with the innocent, but if we can't in America provide counsel to people, we don't put them in jail. Best versus Grant County is a state of Washington case. Again, Washington has a county-based system, right? And most counties in Washington provide services through a contract system where the county commissioners or the county board of supervisors or whatever their county body is called contract with one or more lawyers to provide services directly. And in that case, the suit alleged on behalf of 3 indigent plaintiffs and a taxpayer plaintiff who were bringing class action suit that, again, the state of indigent defense services in Grant County was so deficient that it exposed clients to a continuing risk that their rights would be violated. The court, in granting a partial summary judgment in favor of the plaintiffs, said that indigent defendants in Grant County, Washington had a well-grounded fear of immediate invasion of the right to effective assistance of counsel. And in November of 2005, just weeks before the trial date, guess what? Everybody settled, right? Now, the sad thing about that is that this state of affairs had gone on for so long, and the deficiency in the lawyers with whom the county was contracting was so bad that there were a series of civil suits filed by clients who had been represented by some of those lawyers. Grant County settled just one of those for $250,000. The dadgum lawyer went to trial and got ordered to pay $3 million to his client. Now, his client's never going to see a penny of that, right? Because he's been disbarred and he's got no malpractice insurance. But the county let that state of affairs go on. So I am going to take 1 minute here to tell you, I'm skipping over a whole lot of stuff here, but I'm going to tell you what I see as the single primary thing that you as policymakers in your counties can do to not let this happen to your taxpayers. And that is the first principle of the ABA 10 principles. In your materials, you have a copy of the American Bar Association 10 principles. These are regarded as the most concise, easy to understand consolidation of all of the standards that exist out there for public defense systems. It boils it down and it puts it in very simple language. And the first of those principles is the one on independence. Now, the short version of that says the public defense function, including the selection, funding, and payment of defense counsel, is independent. But it goes on for a couple of sentences after that and explains what that means by a little bit, right? Now, every one of you are responsible in your own counties. And there is nothing in Texas law that prevents the county commissioners and the judges of a county from coming together and saying, we have responsibility for the provision of indigent defense. We have to do it in accordance with the Texas Fair Defense Act. And we have determined that we will establish a nonpartisan public defense commission in our county. We will place them in charge of overseeing the budget that they are given and of determining the mechanism to provide counsel in our county and to ensuring that it's done in accordance with the ABA 10 principles. We will cede to them authority to hire the chief public defender if we're going to have a public defender office, or to hire the administrator of contracts if we're going to have a contract system, or to oversee the appointment of counsel. But what it will do is it will take the judges and the commissioners out of public defense, and it will take the politics out of public defense. We have elections every 2 years in Texas, and the wind blows, right? And I've been a Texan all my life, and, you know, the wind blows, right? Public defense should not be subject to the political winds. Whether or not a person receives effective assistance of counsel should not depend on whether the judge ran on a blue or a red ticket. It just shouldn't, right? So the Texas Task Force is here to provide you with resources to help you know how to do that. What I'm telling you is not new. Harris County is doing it, right? As the public defender office is being set up in Harris County, a public defense commission is being established in Harris County. So it can be done anywhere, and you guys have the power to decide to do it. And once you take yourself out of interfering with public defense, just like you don't interfere with prosecution, and just like you don't interfere with private criminal defense lawyers, then I think you'll find that you're really glad you did, and you'll be proud of the indigent defense services that you're delivering in Texas, and you will no longer have an appearance of impropriety, even where none exists. Because I know you're all good-hearted folks. You wouldn't be here otherwise, and you must care about this, or you wouldn't be spending your time. So don't put yourself in a place where people can throw stones at you and say, oh, you must be interfering with the process, when you're not. Make it clear that you're not by giving that authority to an independent commission. Thank you.